So this is a quick agenda of what we're going to try and cover. I thought it'd be worthwhile just giving a very quick recap about HFW, about what we do, where we stand in terms of our activities in maritime sector, and then with a quick recap of the facts around the Tilawa. For those of you that not have read about the case at all, I'd encourage you to go and read all the judgments. They make very good, interesting reading. The judge in the first instance at the High Court compared this case to a game of Buccaneer, and it is, it's not every day that a case like this comes to all the way to the Supreme Court. So for us as lawyers, it's not only very interesting subject matter, but it is also very rare that we actually take a case like this to the Supreme Court. So just taking things on, we'll then Henry's going to deal with an introduction to UK salvage law and give you a brief overview about that. We'll then talk about the different decisions in the Admiralty Court, the Court of Appeal and the Supreme Court. And then we will look at the changing legal landscape and what this may potentially mean for future claims that are brought to the UK. And again, future claims, implications for other jurisdictions worldwide. Henry, do you want to go on to the next slide?
Sure. Just before I jump on, I wanted to flag one last point, which was that the images, most of the images that you will see through the course of this presentation, and we're very conscious that often our slides will be heavy and legalese, so we've tried to include some interesting pictures throughout to draw your attention. These were taken by and kindly we were kindly given permission to use these images by Deep Ocean Search, which is the company which performed the actual salvage operation. So on the screen there, you can see the results of the multi-beam sonar scan, which located the Tilawa. So that blob that you can see on the screen there is in fact the Tilawa herself. But moving on to the next slide.
Thanks, Henry. I knew I was going to forget something in the intro, so thanks for picking that up. Just by way of background, I thought it helpful if you understand where HFW have come from. We were founded in 1882, so our heritage goes way back, actually by the Holman family, who were ship owners in Topsham near Exeter. In 1883, they set up a number of companies, primarily for insurance of ships. So they started the West of England Steamship Owners P&I Association. And then 6 years later, they went on to form the Exeter Shipping Insurance Association. This was sort of followed by various other companies that were set up later on. So in 1855, they set up the Ship Owners Protection Association, both of which, Ship Owners Protection and West of England, are both still around today and are what we call international group P&I clubs offering insurance for the commercial market. But by 1870, the West of England had become West of England sort of Steamship Owners P&I Association. So this marks the shift for insurers to dedicated steamship insurance. But in 1873, the company moved to Lime Street in London, and one of the four brothers decided that he was going to set up a solicitor's practice in 1883. And that marks the start of HFW. Today, we remain the world's leading maritime law firm, but we have 6 core sectors in addition to marine or shipping. So we have aviation, commodities, construction, engine resources, and an insurance practice. We employ about 700 lawyers worldwide. We have 185 partners, and we're in 21 offices around the world. So many of our partners around the world also have a background in salvage practice and expertise. So you're getting the combined expertise from a lot of other people. So moving on, Henry, to the next slide. Just thought we would set out just a brief outline to the Tilawa herself. Have a picture of her on the slide there. Built in 1924. She was built by Hawthorne Leslie and Company at Hepburn on the Tyne, launched on the 20th of February. She was 137.5 meters long with a beam of 18.1 meters and apparently had a cruising speed of 12 knots. Although she was designed to carry with capacity for 3,290 passengers, she actually carried far less, and on her final voyage there were 732 passengers and about 222 crew. She was owned and operated by the British India Steam Navigation Company, and she spent her time sailing between the Far East. Next slide, Henry. So this was just going to outline the sort of the key facts of her final voyage. So on 23rd of November 1942, she was roughly 1,500 kilometers northeast of the Seychelles when she was torpedoed twice and sunk by a Japanese submarine, I-29. At the time she was sunk, she was sailing from Mumbai to Mombasa and Durban, and amongst her cargo was some 2,391 bars of silver. At the time, the vessel had been requisitioned and was operating under charter with the UK government. The silver itself was being carried under contract to the order of the South African Mint to be struck as coin. This had been purchased from the Bombay Mint on FOB terms. The Indian government, as seller, had arranged the contract of carriage with the owners on behalf of the RSA. And this point is important because it plays into the subsequent judgments that Henry's going to talk about in the next few slides. At the time, the first instance judgment handed down by the Admiralty Court, the silver was worth around 43 million, or about $35 million, about 35 million pounds, broadly the sale value at the time. Should say at the time of the sinking that the unfortunate result was that there was a loss of 28 crew and 252 passengers as a result of the incident. Many of the surviving passengers were rescued. There was a light cruiser that picked them up, the HMS Birmingham, and there was another passenger ship, Carthage, that also managed to collect a lot of the survivors from the wreck. As you can see, the location of the wreck is marked on the image on the chart there. Clearly shows that she is well into international waters. And again, this is another key point that featured in some parts of the judgment. Thanks, Henry. Next slide. So turning then to a recap of the key facts that underpin the judgment and how this case basically was brought to the court. So project was started in around 4th of December 2014 when the wreck was actually located using sonar. And this is when it was confirmed to be the Tilawa using an ROV. Project was fronted by Argentum Exploration, but the actual salvage work itself was carried out by companies Henry's mentioned called Deep Ocean Search. They were subcontracted to carry out the services, locate and recover the silver from the wreck. When they found the wreck, she was lying on her port side, an angle of about 70 degrees, with depth around 2.5 kilometers. And it wasn't until 2017 when project was pulled together and Deep Ocean returned to the wreck to recover the silver. They used a vessel called the Seabed Worker, which the silver was lifted on board, and then this was transshipped to another vessel, Pacific Ascari, which was then used to bring the silver to the UK. In terms of the operation itself, they used an 8-ton shear grab to dismantle sections of the hull to reach areas in the vessel, such as the mail room, specie room, opium rooms, and the final silver bar was eventually, say, recovered in 2nd of May 2017 from cargo hold number 4. So by the time the Ascari reached the UK, this was about, it was landed in 2nd of October 2017. So it took some time. June was when the operation finished, to October to get it to the UK. But anyway, it was landed in the UK 2nd of October 2017. Henry will explain the importance of this date in terms of the appointment and notification of the receiver of wreck in due course. But on the 1st of October 2019, an in-rem claim was commenced, this being almost a year to the 2-year time limit under the 1989 Salvage Convention, in which any claim for salvage has to be commenced. 20th of November 2020, we say there was a separate in personam claim that was commenced afterwards. And again, this plays into the decisions from all the courts, which will come out in due course, we'll discuss shortly. Now, another thing to just point out that unbeknown to the RSA, who were the agreed owners, they had signed a separate agreement with another salvage company on or around the 14th of February 2018 for the recovery of the silver. Although at the time they were unaware that Argentum and their consortium had actually recovered the silver, and that this was well on its way to being landed and declared to the receiver of wreck. So with that in mind and those in context, I'm going to hand over to Henry, who's going to talk about the implications under UK salvage law.
Thanks, Tom. So really, to understand the background to the High Court judgments, I'm just going to briefly explain how salvage law works in the UK. Now, what we have on the screen now is a very helpful quote which appears in one of the leading salvage textbooks, Bryce on the Maritime Law of Salvage, and it appears on page 1. The book then takes, I mean, almost 1,000 pages to explain what it actually means in great detail, but taking it at its very highest level. Under English law, a right to salvage arises when a person acting as a volunteer preserves or contributes to preserving at sea any vessel, cargo, freight, or otherwise recognized subject of salvage from danger. And if all those various parts of the test are satisfied, then the person who does so is entitled to a common law salvage award. Now, in this context and thinking about the Tilawa, by raising the silver and delivering it to the UK, Argentum had effectively satisfied this test. So they were not under a pre-contractual duty to salve the silver. They did so unprompted, and there is a requirement for the property in question to have been in danger. Now, query to what extent property such as a silver bar, which whilst it will corrode slightly, being under seawater, is broadly untouched, how much danger that silver bar is in. But the English courts have found that where property is infructuous, i.e. cannot be used for an economic purpose, then it will be in danger for the purposes of salvage. So that criteria is met. The services performed have to be in the nature of salvage services. So raising, recovering, and delivering the silver to the UK, that satisfies that criteria. And there must be a success or benefit conferred. So the common law salvage is no cure, no pay. If you don't succeed in saving anything, then there is no award. But here, where the property was salved and delivered to the UK, then that criteria is satisfied as well. Now, this test, it is a quirk of English law. This test applies equally to modern commercial vessels like the one you can see on the screen, and to historic wrecks and their cargoes. So leaving aside the issue of state immunity for the moment, and I'll deal with that in a second, then at least on paper, Argentum had a prima facie claim in salvage for recovering the silver and landing it in the UK. And whilst what that claim is worth was never determined by the English courts, they would be entitled to a percentage of the value of the salved property, and that could raise anywhere up to 80% of the salved value of the goods, given that at the time of the first instance judgment, the Admiralty Court determined that the salved value of the property was $43 million. There was about $32 million worth at stake in this particular case. So once the property is salved, there are certain other requirements under English law that a salvor has to satisfy, particularly when it comes to the salvage of wrecks. So any person recovering wreck and landing it in the UK must notify the receiver of wreck. If the salvor fails to do so, then he forfeits any claim to salvage and can be liable to pay twice the value of the wreck, and that's under the Merchant Shipping Act 1995. Once the salvage property is landed and declared to the receiver of wreck, then the receiver of wreck will then investigate the ownership of the salvage property and try to identify the legitimate owner. And there are various different ways that he will go about doing so. One of the key ways is that a notice is posted by the CEO of Lloyd's in some conspicuous position for inspection. The theory is that a vessel and cargoes are likely to be insured in the London market, and therefore a notice at Lloyd's will put the relevant underwriters on notice that the property has been recovered. Lloyd's will typically do this by publishing the information in Lloyd's list or in their notices to underwriters. Now, if within a year the owner of the salvage property proves to the receiver's satisfaction that they'd have ownership of the wreck, then they will be entitled to possession of that salvage property, or if it is sold in certain limited circumstances, to the proceeds of sale, once they have made a payment in respect of salvage fees and expenses due. Now, in this particular case, our clients, the Republic of South Africa, came forward and claimed ownership of the property on the 14th of September 2018, i.e. just a couple of weeks short of that 1 year deadline. Now, the Republic of South Africa's right of ownership of that property was initially disputed by Argentum, but that was later accepted, and Tom in a little bit will explain the nature of that dispute. Now, crucially, now to get into the slightly heavier legalese of this particular topic, as set out in the previous slides, Argentum commenced two sets of proceedings, one in rem and one in personam. Now, an in rem claim is a claim against a res or thing, such as a vessel or a cargo, and the property itself is treated as the defendant. An in personam claim is made against a person or a legal entity. Now, as Tom explained, the in rem proceedings were commenced on the 1st of October 2019, and that timing is really important because that is 1 day before the 2-year anniversary of the goods being landed in the UK. And that timing is really important because, as Tom explained, the time limit for commencing a salvage claim under English law is 2 years, and the in rem claim was therefore brought in time. The in personam claim was commenced on the 20th of November 2020, i.e. more than 2 years after that, after the goods were landed, and that claim was arguably time barred. Nevertheless, that in personam claim was commenced and began to start making its way through the English court system. Now, crucially, the in personam claim in this particular case stalled because of a requirement for the claimant Argentum to serve the defendant, the Republic of South Africa, and it's that process of service of the claim which really kicks off proceedings. Now, service on a foreign government of another country requires service to be performed via diplomatic channels, and that can be, depending on the country, a very slow and lengthy process. And that meant that by the time that this case by the time the in rem claim got as far as the Supreme Court, the in personam claim had not been served on the Republic of South Africa. I believe that's right, Tom. Please jump in if I've got that sequence of events
No,
wrong.
that's fine. I was just going to say, I mean, often the reason why parties decide to start an in rem claim is because it's very easy to serve. It's the old march it up the gangplank and attach it to the ship, or attach it to the cargo, which is exactly what they did. They posted or attached the claim form to the cargo, and that was considered good service. As you've said, the in personam claim is far harder to perfect. You have to serve out of the jurisdiction if the property or person isn't here, and you have to satisfy various gateways. and that is far harder to do. Bear in mind as well that when all of this was going on, we were in the midst of COVID, and so serving anything through diplomatic channels was incredibly challenging at that time anyway.
Yeah, I mean, so I seem to remember the foreign process section, which is the specific court part of the English court system who performs that function. The foreign process section actually shut for a number of for a period of time during 2020. So there was enormous disruption going on at the time. So after Argentum commenced the in-rein proceedings, the Republic of South Africa challenged the jurisdiction of the court, and it did so on two bases, and effectively argued that the English courts did not have jurisdiction to hear the claim. Now, the first basis was under Section 10(4)A of the State Immunity Act, and the second basis was Article 25 of the Salvage Convention. And in particular, I want to draw your attention to Sections 10(4)A and B of the State Immunity Act. Well, Section 1(1) of that Act states that a state is immune from the jurisdiction of the courts of the United Kingdom, except as provided in this Act. And Section 10(4)A goes on to state, a state is not immune as respects an action in rem against a cargo belonging to that state if both the cargo and the ship carrying it were, at the time when the cause of action arose, in use or intended for use for commercial purposes. Now, importantly, we also need to take a look at Section 10(4)B. The test under Section 10(4)B is slightly different. For in personam claims, the test is actually a little bit simpler. Only the only the ship needs to be in use or intended for use for commercial purposes for Section 10(4)B to apply. Okay, now going back to the test at 10(4)A, there were a number of issues that the English courts had to grapple with when it came to the interpretation of this provision. So, first of all, it was the question of what does, at the time when the cause of action arose, mean? Does it mean back in 1942 when the ship was sunk, or does it mean when the vessel was actually salvaged? And secondly, the court also had to deal with the question of what does, when is a ship or a cargo in use or intended for use for commercial purposes? Now, ultimately, the parties agreed that the vessel was being used for commercial purposes, and that makes sense. The vessel was privately owned and was operating under a time charter with the UK government. All arrows point to it being in use for commercial purposes. So really it came down to, was the cargo, as it sat in the hold of that ship at the time of the sinking, in use or intended for use for commercial purposes? So the dispute arose, and the Republic of South Africa argued that it was immune, that it was entitled to state immunity, and that the cargo was immune. The parties therefore went to the Admiralty Court to try and find an answer to this. And for those of you who haven't come across the Admiralty Court before, it is a specialist subdivision of the English High Court that only deals with Admiralty claims. And those are claims relating to, for example, arresting ships, collisions between two ships, or the salvage of property at sea. So when you go before the Admiralty Court, you are dealing with a judge who is steeped in knowledge and experience of all things marine. So what was the decision of the Admiralty judge, who was a Mr. Sir Nigel Tier at the time? Well, based on the documents found in the archives of the India Office and the Dominions Office, which are held at Kew and in the British Library, Sir Nigel Tier held that the government of India had sold the silver to the government of the Union of South Africa on FOB terms. The government of India had arranged the shipment of the silver, but the government of South Africa had paid the freight and was a party to the contract of carriage. The silver was for use by the South African Mint, and the Mint was producing coin for the Union of South Africa. And crucially, that was a sovereign act. However, he also found that the Mint was also producing coin for the government of Egypt, and that work for other governments was done for profit, and this was a commercial activity. Now, notwithstanding the fact that the silver had a mixed purpose, the judge concluded that the silver, that 80% of the silver was to be used for the production of South African coinage and 20% for Egypt, and therefore the silver was predominantly to be used for a sovereign purpose and not a commercial one. Moving on to the question of in use for a commercial purpose, the Republic of South Africa in the Admiralty Court argued that a cargo on board a ship is not in use. So the silver was not in use after it left India. It's not in use. It's just sat in the hold doing nothing. The fact that they also argued that the fact that the silver had been subject to a commercial sale was irrelevant. They went on to argue that the silver was not intended for a commercial purpose because it was for use, predominantly for use to produce coinage for South Africa, i.e. a sovereign purpose. And when Argentum's cause of action arose in 2017, neither the silver nor the vessel was in use or intended for use, and therefore they said that the silver was entitled to state immunity. However, Sir Nigel Tier, the Admiralty judge, held that the court had to take into account the use of the ship and the cargo at the time when the ship was carrying that cargo, i.e. in 1942. He held that both the ship and the cargo had been in use for commercial purposes because the silver had been sold under the terms of a commercial contract and carried under a bill of lading. He went on to find that the fact that the silver might have been intended for use for a sovereign purpose, i.e. the production of coin for the state of South Africa, did not detract from his conclusions, and therefore he held that the Section 10(4)A exception applied and that there was no entitlement to state immunity. So, not particularly happy with that conclusion, the Republic of South Africa appealed, and that appeal was heard by the Court of Appeal. Just to give you an idea on the timeline for these events, the first instance decision by the Admiralty Court was handed down in 2020. The Court of Appeal judgment was handed down in 2022, and ultimately the Supreme Court judgment was handed down in 2024. So this was a drawn-out process that took a fairly considerable period of time. And what you can see, by way of explanation, what you can see in the screen here is an ROV being used to load the bars of silver into the bucket of a grab, and from a depth of, I think, 4,200 meters, and then raise it up to the surface. So the case was appealed and went before three Lord and Lady Justices of the Court of Appeal, and it was a split decision in the Court of Appeal. I'm not going to dive into that decision in great detail in the interest of time, but in short, two of the three justices, so Lord Justice Popwell and Andrews, upheld the first instance decision, i.e. saying that the silver was in use for commercial purposes, and the third Justice, Lady Justice Lang, issued a dissenting judgment stating that the silver was not in use by the government for any purpose, commercial or otherwise, at the relevant time. So where the Court of Appeal judgment is also interesting is in relation to the powers of the receiver of wreck. Now, at the second day of the two-day hearing before the Court of Appeal, the court asked the question of whether the receiver of wreck had the power to determine salvage, and whether the receiver of wreck was obliged to only release the silver after salvage had been paid, i.e. even if South Africa could invoke state immunity. The hearing was adjourned to allow the receiver of wreck to intervene, and for the parties to make further submissions. Argentum argued at that once that hearing was reconvened that the receiver must, by implication, have the power to determine salvage, and that because Section 1.1 of the State Immunity Act only refers to courts and not to the receiver of wreck, any decision by the receiver would not be subject to state immunity. And in any event, they also argued that the receiver had no power to release salvaged property without salvage being paid. Now, this was an interesting argument because if they were right, then even if the silver was subject to state immunity, the receiver had no power to release the salvaged property without something being paid to the salvor. And that would have the effect of effectively trapping the silver in the UK until the RSA submitted to the jurisdiction of the UK courts or abandoned the silver. So Argentum were effectively trying to compel South Africa to come to the UK and deal with the case. However, ultimately, the Court of Appeal agreed with the submissions made by the Republic of South Africa and the receiver of wreck, holding that Section 226(1) of the Merchant Shipping Act did not grant the receiver of wreck the power to decide whether salvage is due and how much. That is always going to be a question for the English courts. And secondly, they held that the receiver of wreck is not required to continue to detain a wreck if a state successfully invokes state immunity. Nevertheless, Argentum had won. They had two of the Court of Appeal justices had sided with their arguments at the Court of Appeal. So South Africa appealed again, and Argentum filed a cross appeal as well. And ultimately, that appeal was heard by the Supreme Court in 2024. Now, here you can see two photos of the deep ocean search team sat on the pile of silver bars after they had been salvaged and brought on board the seabed worker. You can see, that there is a degree of corrosion, but ultimately they were in relatively good condition. So it all goes before the Supreme Court. Now, the hearings before the Supreme Court are recorded, they're publicly available. We would always encourage you to go back and watch these things. It is always interesting to see how these cases play out. But ultimately, the Supreme Court held that on the issue of timing, and you'll remember that provision in the State Immunity Act, that the relevant time is the time when the cause of action arose. Now, on this point, the Supreme Court held that it was appropriate to have regard to both the use and intended use of the ship and cargo at the time when the ship was carrying that cargo, i.e. 1942, and also have regard to whether that use had changed during the intervening period. Now, in this particular case, they found that there had been no change, and therefore it was necessary to look at what was happening in 1942. Coming to the question of usage and whether the cargo had been in use for commercial purposes, they held that, the Republic of South Africa argued that the approach adopted by the judge of first instance in the Court of Appeal ignored the natural meaning of in use and ignored the words intended for use in Section 10.4a. It also argued that the approach taken by the judge and Court of Appeal removed the distinction between the two limbs of that test, 10.4a and 10.4b. And 10.4b, of course, is relevant for in personam claims. Ultimately, the Supreme Court held that if the lower courts were right, then every state-owned cargo carried on a commercial vessel would be in use for commercial purposes, and the test for 10.4a would effectively be the same for 10.4b. And the distinction between the two would also gave effect to Article 3.3 of the Brussels Convention. They held that a cargo carried on a ship would rarely, if ever, be in use for any purpose, because when a cargo is on board a ship, it is simply being carried. It is not in use. And just because the cargo had been sold under a commercial contract and carried under a bill of lading did not mean that it was in use for commercial purposes. Instead, they held that you should look to the use or intended use that the state had decided to put the cargo to, and that was predominantly the minting of coin for the Union of South Africa. And that was, of course, a sovereign activity. The Argentum also ran an argument that Section 10(4)A of the State Immunity Act had to be read down under Section 3 of the Human Rights Act 1998, because the government's immunity would exceed that required by customary international law and would constitute a disproportionate interference with the right of access to a court under Article 6 of the European Convention on Human Rights. The UK Supreme Court found that Argentum had two routes to pursue a claim in salvage, the first in rem, which was the claim being dealt with, and the second in personam. The immunity claimed by the government of South Africa only applied to the in rem proceedings, and a claim could be brought in personam. On that basis, the immunity conformed with general principles of international law, and ultimately the Supreme Court dismissed this line of argument. So the takeaway from this was that the silver was declared to be immune as regards in rem actions, because at the time the cause of action arose, the silver was intended for non-commercial purposes, i.e. the minting of coin for the South African state. So what are the conclusions that we have from this? Well, just because there is a contract of carriage in place for a state-owned cargo does not mean that state immunity is lost. This was also an interesting series of decisions because it was the first time that the English courts had to consider this issue in this context. And this judgment, whilst not binding on other jurisdictions, will be considered to be persuasive in places like Hong Kong, Australia, South Africa. And so this is a fairly wide-ranging and impactful decision. Nevertheless, claims in personam could and would still succeed, absent issues around time bars and so on. And it's also an interesting series of decisions as regards the powers of the receiver of REC.
Henry, I was just going to add, there's probably an even broader purpose as well. It goes much further and just highlights the importance of establishing ownership of any particular cargo, and working out who actually has title to that and where title has passed. It's certainly something we've seen on subsequent instructions that we've received. It's one of the things that we've been discussing, and that is very important in establishing any claim in light of this decision.
Yeah, no. So and in this particular case, it was difficult due to the fact, at the time South Africa was the Union of South Africa. There had been a change in the government now in South Africa is, of course, the Republic of South Africa, and so that chain of ownership reaching back 3 years was something which had to be considered and was the subject of quite a lot of research. Moving on to the current legal landscape. Well, there's a significant amount of legislation which protects wrecks such as the Tilawa and other wrecks in the UK. However, they have their limits, and this is the reason why we wanted to flag this topic in the next 5 minutes or so. Is that the existing legislation is potentially going to change in the coming months because of some amendments to certain legislation, which I'll go on to discuss. But it's worth noting that the Protection of Wrecks Act and Ancient Monuments and Archaeological Area Act are both in place, and they allow for the designation of certain sites to protect them from unauthorized intervention. It is, however, worth noting that both of these acts are the powers granted by these acts are limited to UK territorial waters. The Protection of Military Remains Act 1986 is slightly different in that it allows the Secretary of State for Defence to designate the site of wrecks to be either protected places, which is where diving is permitted, but there's a strict look but don't touch rule, or a controlled site where no diving or disturbing the sites is allowed. Now, the requirements for a wreck to be a protected place is that the vessel must have sunk after the 4th of August 1914, which is, of course, when the UK declared war against Germany at the commencement of World War One. And crucially, the vessel in question must have been in service with or being used for any of the armed forces in the UK or any other country or territory. Now, for controlled sites, the time limit is less than the limit is less than 200 years have passed. And it's an interesting piece of legislation because it has a global reach. It is not limited to UK territorial waters as the other piece of legislation I've just discussed are. There's no need for service personnel to have actually died on board those wrecks, notwithstanding the name of the act. There's no need for the ships to have sunk during wartime. But there are limits to this legislation. It requires an active role to be taken in designating the vessels as protected places or controlled sites. And to date, 113 vessels have been designated as protected places, and there are 16 controlled sites. So despite this having come in 1986, it currently only protects a small fraction of relevant vessels. I also just want to flag, as you can see, I've mentioned the UNESCO 2001 Convention on the Protection of Underwater Cultural Heritage. There are 81 signatories to the convention at the moment. The most recent country to have ratified it is Ireland, but crucially, the UK has not ratified the UNESCO Convention. Instead, it has adopted the rules of the annex as best practice when it comes to managing sites and marine licensing. It does not, however, have the force of law in the UK. However, there are changes on the horizon, and that is in the shape of the Armed Forces Bill, and which is 2026, which is currently making its way through Parliament. It is currently at the committee stage. This is the Armed Forces Bill is, of course, a very wide-ranging bill, which is designed to renew the Armed Forces Bill 2006, which is the primary legislation governing the UK's armed forces. However, right at the end of the bill, section 47 under miscellaneous provisions, there are some proposed amendments to the Protection of Military Remains Act. Now, these proposed amendments will have a significant impact. Well, first of all, the Act will automatically apply to vessels which were in military service, removing the need for designation before a wreck becomes a protected place. So that is probably the biggest change. Any wreck which was in military service at the time of its sinking will automatically become a protected place. Secondly, a cut-off of that I talked about before of the 4th of August 1914 will be removed, extending those automatic protections under the Act to all vessels lost in military service, irrespective of when they sank. And similarly, that 200-year limit for the designation of an area as a controlled site will also be removed. So we're looking at the potential strengthening of a significant potential strengthening of these protections for historic wrecks. There is, however, a potential issue with this draft legislation, and it's around the meaning of in military service. And there seems to be a little bit of confusion on this point by all parties involved. and it's important to think about a case which happened a fair few years ago, so 2006, which was the decision in R and Fog, which was the first case which involved the interpretation of the Protection of Military Remains Act. Now, R and Fog was a case that concerned a vessel called the SS Storer, which was a merchant vessel sunk in 1943 when she was sailing in a naval convoy. Now, the vessel was armed, she had a deck gun and certain other protections, and was carrying a number of military personnel, naval and army gunners, whose role it was to protect the vessel as it was sailing. Now, when she was attacked, certain people were killed, including one or more of those gunners. And the family of one of those gunners who had died asked the Secretary of State to designate the Storer as a protected place under the Protection of Military Remains Act. Now, the Secretary of State refused protection, arguing that the ship was not in military service because at the time it was a merchant vessel. And the relatives of the gunner challenged this decision in court, and effectively took the UK government to court. And ultimately, the Court of Appeal ruled that the interpretation of "in service with" was too narrow, and they ultimately held that a vessel can qualify as being in military service if it is under naval command and Admiralty control, i.e. subject, in this particular case, they said subject to the Naval Discipline Act of 1866, regardless of the fact of whether it was a civilian vessel. Now, this case significantly expanded the Act's scope to include civilian vessels operating under military authority. So what we're seeing, what is the impact of all of this? Well, if these proposed changes go through, then not only will the amended Protection of Military Remains Act apply to all warships, or apply automatically to all warships, but it will also automatically apply to all civilian vessels which sank whilst they were sailing in convoy and were subject to the Naval Discipline Act of 1866. Now, in the context of World War II, that will be a relatively straightforward question to answer. At the time of the sinking, was a wreck in question sailing as part of a convoy and subject to to military command? That will be, however, a much more difficult question to answer if we then start thinking about older wrecks, where the evidence will be much less good. So you then get into questions about, what about older armed merchantmen at the time? Were they in military service? What about privateers, if we then start looking further back? And that is something which I think will be of interest to courts and elsewhere going forwards.